having supposedly breached a contract by finding that he was required under the contract to pay any amount that was billed to him for his water and sewer fees, even if that amount was inaccurate. That reading of the contract was wrong, and therefore the lower court should be reversed. Specifically, the trial judge cited the utility addendum, paragraph 2, which says in essence that if an allocation method is selected, the amount billed ultimately may not be entirely accurate, but the parties still agree that it would be fair, that an allocation method would be fair. The reason why the judge was wrong to rely on that paragraph is twofold. One, it specifically says if an allocation method is selected, and here no allocation method was selected. If you look at paragraph 1 of the utility addendum, there's a box that would need to be checked for an allocation method to be selected, and then there's a line after the sentence that would need to be filled in with a number of 1 through 10 to select a specific allocation method. The box is unchecked, the line is left blank. And then if you would like an example of how an allocation method would be selected, you could look at the paragraph 1D of the utility addendum, which refers to trash pickup, and then it has the box is checked, and then it has the number 4 allocation method selected, which is for a flat fee.
There is a box checked, though, under that addendum for the third-party billing. So why would that box be checked if, I mean, it seems like to me that would only be checked if allocation was being employed.
I would say that box is checked just to show that you're not expected to send your water bills directly to the utility company, which is what the higher box, the earlier box would be checked to show. Instead, they're saying we're expecting you to send it to our third-party company. But again, the reason why I mean, even if that third-party box is checked, they still haven't agreed on any allocation formula. They haven't agreed that what paragraph 2 under the allocation method specifically says, it says, if any allocation method is used, we will calculate your allocated share of the utilities. And then it says, under any allocation method, resident may be paying for part of the utility usage in common areas or in other residential units, as well as administrative fees. Resident and owner agree that using a calculation or allocation formula as a basis for allocating total utility consumption is fair and reasonable, while recognizing that the allocation method may or may not accurately measure the actual total utility consumption. And so,
did the third-party entity here agree that there were inaccuracies in their billing? Did they concede essentially inaccuracies?
They conceded. I mean, the main disputed period was from, I think, November 2017 to June 2022, which adds up to about 68 months. They conceded that, they in essence conceded that at least 10 of those months were wrong. And the reason I say that is because they admitted that they didn't get correct readings on that, and that they were therefore just going to estimate the correct amount in those 10 months. So 10 months that they're admitting wrong out of 68 months, they're admitting that they're wrong for at least about 15% of the time. Beyond that, we've specifically pointed to a number of other months during that period where the readings would have to be wrong. The jumps just don't make any sense.
What is the fluctuation on the billing? I mean, what are we seeing in the billing in terms of the high end, low end of the bills that are coming in?
Well, before November 2017, Mr. Smythe's billing, I think he testified, was always under $11 per month. And then after June 2022, so July and later, it was similar to that. It was, I think, always under, I forget the exact number, but it was always like about 13 or less. And so there really shouldn't have been any fluctuation at all. Mr. Smythe testified that his water usage for the entire years-long period should have been the same as it was pre-November 2017 and post-June 2022. And so if you credit his testimony, it shouldn't have ever changed from that roughly $11 per month. To settle the matter and try to make everyone happy, he had always for years offered to pay the apartment complex an even higher amount of, he said, $15 a month, just to, you know, make sure that he was covering everything, and they had consistently refused to accept that. But if you accept his testimony as true, then it should have been, you know, 15 or less the entire period, more like 12 or less probably. And the judge ultimately said that she did accredit Mr. Smythe's testimony. She said that he was credible and earnest, and so I submit that's a credibility finding that there's no reason to overturn on appeal, and it's entitled to a presumption of correctness. But again, so the judge basically agreed with Mr. Smythe on the facts, but she just said, well, under this paragraph 2, the billing doesn't have to be accurate, and so it doesn't really matter whether he's telling the truth. And I just submit that she was incorrect on that. Aside from the fact that no allocation box was checked and no number was filled out on the line, the other problem with relying on paragraph 2 of the utility addendum is that by its own terms, I don't think it would justify just any inaccurate billing that the third party may choose to impose. What it says is that basically additional fees could be charged due to administrative costs, and so that's that $3.63 per month that I submit is illegal. But under paragraph 2, if you applied paragraph 2, that part would be legal. And then it also says that they can bill extra for the common areas and possibly for other units. However, in this case, RealPage never testified that it was billing Mr. Smythe for any common areas or for any other units. It said that it was specifically billing him based on the meter in his apartment. And so even if number 2 applied, I just submit it really shouldn't even change the outcome other than to allow that $3.63 administrative fee. But since paragraph 2 should not apply, even that $3.63 fee shouldn't apply either, and that's a fraudulent, invalid charge that adds up to over $300 over the course of the years-long period we're talking about. And then I further submitted, I'm not sure to what extent we need to rely on these affirmative defenses, but we did cite the defenses of waiver and impossibility, and that's basically just saying that if Mr. Smythe is trying to pay what he rightfully owes and the apartment complex refuses to accept it, then it's impossible for him to pay, and they've further waived the fee by refusing to accept it over the years.
But how does the lease provision against waiver then play with that argument?
Well,
I mean, don't we have to honor that provision? I mean, there's no dispute about the language there.
I did cite a statute, and honestly I forgot to write it down, but I cited a statute in my reply brief that would seem to countermand that lease provision, and so I would say, 1, we don't have to honor it, and 2, the specific language of that lease provision seems to be talking about after litigation has begun, and so during the period we're talking about was way prior to litigation having begun. So even if we did accept that provision of the lease, I would just submit that provision should not prevail, and I don't think it would apply to the doctrine of impossibility in any event. And then finally, assuming that Mr. Smythe did not breach the contract, what we've got is Trelleborg Cadence signing a fully integrated contract in April of 2022, which says they'll accept his rent at their office, that's in paragraph 6, and then give him a place to live, which is the whole purpose of the contract. And they honor it for 1 month, which is April 2022, when they accept his rent, but then the next month they stop accepting his rent, and then they sue him, and then force him to sue him for things that happened many years in the past, try to take away his place to live, and force him to pay for an attorney, pay $26,000 in fees to be stored by the clerk that he's losing interest on. And so we just submit that if Mr. Smythe didn't breach the contract, the apartment complex did, and therefore he should be entitled to that claim as well. If there aren't any more questions, I will come back for rebuttal.
Good morning, Your Honors. My name is Jonathan Cole, and I'm here on behalf of the original plaintiff in this matter, which is the landlord, Trelleborg Cadence. Your Honors, this case is relatively simple. The defendant, the tenant, has tried to complicate it and make it into something that it wasn't. Mr. Smythe, the tenant, was a resident of this complex from beginning in April 2015 and signed a lease at that time, which is substantially the same as the one that he signed in April 2022. Each year he signed the same lease. And it had specific provisions in which it provided that utilities would be paid by the tenant. It also included a utility addendum and along with 5 other addenda as well that kind of pertain to other unrelated subjects. Now, Mr. Smythe signed this lease after having the chance to review it, and he testified that nothing was ever misrepresented to him, and whatever Cadence through its representatives said to him was carried out. The lease contains several specific provisions that controlled the situation. First of all, Section 7. That's the one on the front page of the lease itself. That's one talking about utilities. And some of the language in that is that you'll, which would be the tenant, pay for utilities or services, related deposits, and any other charge or maintenance fees related to those utilities or services. It also goes on to say, if any utilities or services are sub-metered for the dwelling unit or prorated by an allocation formula, we will attach an addendum to this lease contract in compliance with state agency rules or Sydney ordinances. As I mentioned, there was an addendum that was attached to it about utilities.
Counsel, let me ask you a question about that addendum. It
Yes, sir.
provides the method metering or otherwise measuring the cost of utilities will be indicated below. And I don't see where on here the method is actually indicated in terms of how we're going to assess cost with regard to determining what those utility fees are. Where on the addendum does it actually indicate what the method is for determining cost?
It doesn't specifically, Your Honor. It has 10 different categories, which it could be, different combinations, how it could be done, and presumably there should be a designation of that, but it's silent as to that point.
Okay, so if that's the case, then how do we get past opposing counsel's argument here that if an allocation method is used, there is no allocation method that is ascribed here. There's nothing that's stated in terms of how we're going to determine what these costs are. Doesn't that make paragraph 2 or section 2 there inapplicable?
It doesn't, Your Honor, because actually the language of the agreement, specifically in paragraph 2 of the addendum, says if an allocation method is used, not if it's selected. So yes, it'd been better if it was more clear about what was being, which of those methods or a combination thereof was being used. However, it's not whether or not it's selected; it's whether or not it's used.
So do we have an agreement here in which we have no agreement as to cost or as to method of determining cost?
Well, on the first page of the lease, before the addendum itself, he does agree to basically pay anything that is assessed to him in terms of for his utility cost. And so, yes, it would be better if that would have been more specific in the addendum itself. However, you don't have to even go to the addendum. If they hadn't included the addendum, that would be an issue, but they did.
But under that reading, couldn't they charge him anything? I mean, we're charging you $100,000 this month for water. And that would be due under your reading, isn't it? I mean, and he's saying this is an inaccurate billing. He seems to have been complaining from the beginning that it was an inaccurate billing. There's no indication of what the costs are. There's no indication of how you're going to determine those costs. And so has he just agreed to any amount that is set by the third-party biller?
He has, but there's a reasonableness presumed in all contracts. And so, yes, with your example, Your Honor, that would be an issue. However, he's agreed to it. And specifically in that addendum, there's language in which he says, that both parties agree that the use of allocation or calculation as a basis for estimating a total utility consumption is fair and reasonable. He specifically agreed to that.
Haven't we also agreed to a contract that specifies that the method will be indicated, and it's not?
Well, it doesn't say that it will be. It says that if an allocation method is used, Your Honor.
In the lead-in to the marked provisions, responsibility for payments of utilities and the method of metering or otherwise measuring the cost of the utility will be indicated below. And it's in very small print. My eyes are not what they once were, but that seems to be right next to number 1 on the utility addendum.
But it does designate that a third-party billing company will use it And so it does
Is-
provide that, you know.
Is that a method of metering or otherwise measuring the cost of the utility?
Well, it's using a third-party billing for that, Your Honor, and we had testimony at trial, you know, from the third-party biller that came in, and their representative testified that the method that they used in terms of, you know, that there was a sub-metering process and that it was assessed basically based on that. Some months, if it looked to be out of order or out of line with what was used before, it was the amount was ratcheted down in favor of the tenant. However, but that allocation method was used, and there's specific testimony in the record about how that was used by the billing company, and then therefore, you know, assessed by the landlord to the tenant.
And this, I'm not sure I completely understand the sub-metering process in this, tell me what that means in practicality for this apartment complex.
Basically, they receive like a common bill for the entire complex is how it works. And this, I don't know the number of units, but I presume it's in the hundreds, and it's out in the Brentwood area. And so so they would take the total bill, and there's a sub-meter that they read about usage from each individual unit. And so they would take that and get a reading based on the number of gallons that were used. I'm not sure if it combines hot and cold water, but I think it's just general water usage. And so based on that, there's a calculation you know, assessed to each tenant and their percentage. And so basically the whole bill was divided up among the tenants on the property. That's the way. And that testimony went uncontradicted. The defendant, the tenant here, didn't have any evidence supporting any claim that the readings were out of line or have any specific contradictory proof that the readings were inaccurate.
So no proof here that he was paying a disproportionate share versus the other tenants in the complex?
That's correct.
Okay.
And you know, on cross-examination, he admitted that, you know, he's not a contractor, he's not an engineer, he's not worked for a utility before, had kind of no specific knowledge and had no specific readings himself. And so there's nothing that was put in the record to contradict. You know, that was the testimony that came from the billing company about how they did this process, how it was applied. And yes, there are some months that they couldn't get a good reading, but it's fairly normal practice that an estimate is put forth, and that's what is assessed against the individual, the tenant, through that process. And so, but specifically, you know, he agreed, you know, through this addendum that it'd be fair and reasonable. And so therefore, basically, he's waived any claims that he had otherwise. Also, the lease had specific provisions about default, section 33, that provided that if you didn't pay rent or other amounts that you owe, that'd be a grounds for default. And that the utility addendum itself provides that the failure to pay utility bills is a quote, a material and substantive breach of the lease. And then talking about the waiver issue, that section 33, there's two provisions that apply. Section 33 provides that the acceptance of rent or other payments after default are with a reservation of all rights and remedies. Quote, accepting money at any time does not waive our right to damages, past or future rents, or any other sums, or to continue with eviction proceedings. And then also, there's specifically a no waiver provision, and it's entitled that way, sections 36, which is right after that, which basically kind of has that in more specific language, that any acceptance of rent or anything else basically doesn't waive anything. And notably, you know, and I'll get to this in a minute, but you know, the lease also contains very specific attorney's fees provision, and broader than what we normally see. It doesn't even just, you know, it's not just a general one that any reasonable attorney's fee. It provides kind of a two-part assessment. One, if a claim has had to be brought by the landlord to enforce the terms of the lease, presumably eviction and other, you know, for past rent and other things that you would see, that it was entitled to attorney's fees. Then it had a second sentence right after that. You know, if the landlord is forced to defend any claim brought by the tenant, it is also entitled to reasonable attorney's fees for those. So a two-part, both for prosecuting an action and defending an action, which came about in this case.
Counsel, would you agree that the abusive discretion standard in terms of the attorney's fees issue in this case?
It is an abusive discretion standard, Your Honor. However,
so why is this an abusive discretion?
Well, it is because you know, the case law talks about that if the trial court's reaching a logical conclusion or basis decision on clearly erroneous assessment of the evidence or employed a reasoning that causes an injustice to the complaining party, that it should be reconsidered by this court. And we submit that, you know, that clearly here I hadn't even gotten into it yet, but, you know, when we brought, on behalf of the landlord, and actually other counsel, brought the original eviction proceedings in General Sessions Court and generally prevailed there. And then the tenant appealed the matter into Circuit Court, Williamson County. And he didn't just assert, you know, basically a review of what had happened there. He greatly expanded the case. He asserted 6 causes of action: intentional misrepresentation, breach of contract, tortious interference with contract, conversion, violation of the Tennessee Consumer Protection Act, and violations of RICO. He also asked for injunctive relief and to have class certification of all the different tenants there that were kind of affected by this and, you know, governed under this lease agreement and then also this third-party billing company. He also added the third-party billing company as a defendant. And so it's greatly expanded, particularly why the case became much more concerned. That's when my firm actually was brought in as counsel to deal with that and concerns about the class action certification that he was seeking. And so through a process, the defendants of the counterclaim and the third-party claim moved to dismiss those causes of action. And the Real Page, which was the billing company, was able to, the one particular claim against them was tortious interference, and that was dismissed. The other claims, generally, the RICO, Consumer Protection Act, were dismissed by the trial court as well. The tenant basically abandoned his conversion claim at that point, and so the trial court found that there's enough proof to go forward to trial on the intentional misrepresentation and the breach of contract issues, and just against the original plaintiff, which had become the defendant in that matter, which is my client, you know, Cadence.
Counsel, let me ask you a question. We have, in this situation, as I understand it, how far back does the water bill go?
It goes back, he stopped paying in around April or May of 2018. And so by the time we got to trial was in December of 2022. It was about 4.5 years that he had stopped, he had unilaterally stopped paying that period of time.
And as I understand it, he signed a new lease agreement every year.
He did, yes, sir, in April of each year.
So if I'm understanding correctly, what you're doing, what you're alleging here is that even though he's fulfilled that lease agreement and he signed a new lease agreement each year going forward, you're reaching back and saying, oh, but you owe me this water bill dating back to 2018 or whatever the date may be. Isn't that a problem?
It's not, Your Honor, because it was clear to him whenever he would sign it that the landlord was not abandoning that claim. You know, as I went through those waiver provisions, it was not abandoning. You know, it had the right not to abandon those claims, you know, for the water bills.
So, but what he's doing, or what essentially the legal effect is, what you're saying is that he is in violation of his lease agreement the moment he signs it.
He is, yes, sir.
Okay.
And then he was in violation again immediately. That first month, he refused. He paid his rent, but then he refused to pay the water bill part of it. And so he'd done that for 4.5 years. So basically, you know, unilaterally deciding not to pay.
Everybody knew all about this.
That's correct. And the landlord's representative told him, you know, when he came in that last time, the last lease he signed, which was April of 2022, that, you know, he would need to, that they weren't going to let him go forward in terms of this process of not paying his water bill, that he would have to pay that. He couldn't just pay his rent. And he still signed that lease, same terms as he had before. And so, yes, as soon as he did it in that first month, he was in breach before, but yes, he breached that new agreement right then and was in default.
Is there some reservation of rights language in your contract?
There is, Your Honor, that I talked about that, I think paragraphs 33 and 37, I believe, are the two that where they reserve the right and they don't waive any claims and stuff. And they specifically do talk about reservation of rights.
Does that violate the Uniform Act in any way?
I don't believe it does, Your Honor. This lease is in compliance with any Uniform Act that applies to it. So, in total, we submit that you know, the case law is clear, but particularly in this contract, that the tenant was in default for a period of time and continued to violate it, and violated it again, you know, once he signed it and going forward, and he lived in it, you know, until approximately December 2022, after the trial court's decision granting possession back to the landlord. And so based on that, we submit that, that the judgment should be upheld. However, the court should reconsider the attorney's fees award and remand it back to the trial court for determination more in line with what was incurred to defend, both prosecute this claim that was brought, and then also to defend the claim that was claims that were asserted by the plaintiff.
Before you conclude, the allocation formulas that are available under the lease provision, was there proof to show what formula was, did it match up, the formula that was actually employed, did it match up with one of the options in the lease?
It's a little bit of a combination, Your Honor, because they did, as I mentioned, they would take a reading. There's like a little sub-meter that's located, in like in a utility closet or something that's near each unit, and so they would get an exact reading, but then they would apportion it among the individuals. So yes, it does kind of match the first few that kind of talk about that it will be sub-metered based on individual usage, but it does kind of combine another one of those provisions because there is an allocation, like common areas and things like that, because the total bill is kind of covered by the tenants that are there. So it would be, frankly, probably several of them together. That would be, but there was ample testimony on that at trial.
Counsel, one quick question on that front. The agreement also provides if there's a change that there'll be notice provided. Is there any indication in the record of notice being provided of a change in methodology? I believe it's paragraph 2, and I may be misremembering that, provides that if there's going to be a change, you have to provide notice. Do we have any indication of that in the record of notice being provided?
The only change that had happened, Your Honor, is that the billing company had been used in this method before, and Mr. Smythe, the tenant, had complained about them for some period of time and had been in touch with both the RealPage, which was the provider, and then also complaints about it. The only change that happened was not in terms of how the matter was metered and allocated. The change was that he was billed directly from RealPage, which was the third party for some period of time, and then at some point it came back to where the bills kind of came from Cadence itself. But in terms of how the method was, the sub-metering is used, that did not change at all. Otherwise, appreciate your time, Your Honor.
With regard to this question about reserving rights or whether their rights can be waived, what the contract says is after giving notice to vacate or filing an eviction suit, any rental payments tendered are hereby accepted with reservations of all our rights and remedies. This exception does not waive or diminish, and then it just describes their rights. And so in context, this paragraph that they're relying on seems to be talking about only after the litigation has started or after they've given a notice to vacate.
But the last sentence of that paragraph is not so qualified. I mean, it says accepting money at any time does not waive. And I mean, I get your point that it's a last sentence in a paragraph where the first sentence talks about post-litigation conduct. But the last sentence is more generic. It's not restricted as to time.
I agree that the way that's worded, it's a little bit ambiguous, but I would just submit that the paragraph as a whole does have a qualification, and we should read that last sentence in the context of the paragraph. I would further state that any ambiguities in this contract should, I would think, be construed against the drafter, which is the other party. As far as paragraph 2, though, I submit it's not ambiguous. I think it just does not apply. In terms of this statute I cited, I think it is part of the ERLTA, but it's 66-28-508. It says if the landlord accepts rent without reservation and with knowledge of a tenant default, the landlord by such acceptance condones the default and thereby waives such landlord's right and is stopped from terminating the rental agreement as to that breach. And so I would submit that that overrides the contract if it needs to be overridden. Overall,
is your client still in possession of the apartment?
no, Your Honor. They sort of broke up after this trial, and he had moved to a different place. Our position is that the billing should be billed as though it were being sent to the local utility company. It's just that the actual calculations were done by RealPage, And our position is that those $3.63 fees should be borne by the apartment complex, absent any agreement by Mr. Smythe to bear them. Further, we're saying that because the utility company would be limited to billing Mr. Smythe to an amount that's accurate, then RealPage is also confined to billing him at an amount that's accurate. And again, even in paragraph 2, the only inaccuracies that it talks about is billing him for payments for water usage in common areas or in other apartments. And again, the other side isn't even contending that they were doing that here. And so really, paragraph 2 should have no application. Ultimately, the judge here never found that the water billing was accurate or that Mr. Smythe actually used that much water. She seemed to find the opposite because Mr. Smythe testified in essence that it wasn't accurate, and she testified that he was credible. In terms of whether he's agreed to, the other side has basically said that he's agreed to pay any amount, but it has to, any amount that they bill, it has to somehow be confined to some sort of reasonableness standard. And I just submit that absent any narrowing within the contract itself to define what that standard is, then the reasonableness standard would simply be pay what he actually used, pay the amount that corresponds to what he actually used. In terms of the attorney's fee issue, I would just submit that the judge did not abuse her discretion because she reasonably looked at the factors and she focused especially on the lack of difficulty and the lack of novelty. And the opposing counsel has said that it was somewhat difficult for him to write a motion to dismiss. Even if we grant that, the judge gave him his attorney's fees for the motion to dismiss. Right now he's asking for more to help cover the trial itself and such, and so I just submit that that issue should fail. Based on the reasons we've stated, the trial court should be reversed and the matter should be remanded to the trial court to calculate any damages suffered by Mr. Smythe due to the other side's breach. Thank you all.
Thank you, counsel. We will take this matter under an advisement and review the record and try to get you an opinion as early as possible. We will be in recess to the call of the docket this afternoon.